Good morning, everyone. I want to start by just thanking all of you, my professors, Duncan Kennedy, Mark Dashnet, and all my friends and fellow scholars for making the time to participate in this seminar. I also want to thank the South Asian Law Students Association for sponsoring this event, and the South Asia Institute and the Harvard India Student Group for all their support. As Siri mentioned, I am leading the CPR arm of this research project on land rights and inclusive development within the Indian Federation, with a team of researchers including Pallav, who is doing his LRI here and has been really instrumental in putting together this workshop. So thank you, Pallav, and thank you, Siri. To tell you a little bit about the Center for Policy Research, CPR is a research think tank which was set up about 35 years ago with funding from the Indian Council of Social Science Research, which is the social science research arm of the Government of India. And it is composed of a number of people with diverse backgrounds in academia and in practice, including in the government, in the corporate world, in the non-profit sector, all of whom are working on a range of policy issues that are engaging and affecting India and the Indian state. So Siri already mentioned the broader questions that we are engaging with in this project as a whole. I'll say now something about the questions that, at CPR we have been specifically focusing on. And our project is an interdisciplinary research project where we are primarily investigating the background legal rules and assumptions that structure the property rights of tribals and traditional communities to land and natural resources within the territory of India. A related goal is to see how these legal regimes interact with the political dynamics of the Indian federal system and in turn shape the opportunity structure of central development actors, which include policy makers, civil society and community groups, as well as private investors, and influences their decisions and actions and the effects of those decisions and actions. Siri already mentioned that we are looking at 3 states within the territory of India. This is a comparative study, and these states have been chosen on the basis of geographical, political, population, and constitutional diversity. All 3 states show variation with regard to the numbers and concentration of tribal populations, the levels of social and economic development, as well as socio-political differences and differences within current as well as historical federal dynamics. I just want to show you the states on the map. So Gujarat in the west, Andhra Pradesh in the southeastern part of the country, and Meghalaya in the northeast. Now, the goal of our project is to contribute to both academic research in this field, but also create a knowledge base for practitioners and offer constructive suggestions on how to better negotiate the conflicting concerns between the rights of vulnerable groups and the challenges of development. And with that, actually, it gives me a great pleasure to announce the launch of our webpage. It came together pretty much in time for this workshop, and so you can go on to, we're calling ourselves the Land Rights Initiative India, and this is the webpage. You can please feel free to go and take a look and see what our vision is and what we are trying to do, and all the the papers that we've written and the research that we've done, as well as the workshops that we are organized. There are links to that on the webpage. We also have a Facebook page. So the idea is to create this knowledge base and create these networks. And as Siri mentioned, we had this conference in January where we had a lot of speakers from these states who are working on these issues at a micro level come and speak. And not only are those videos online, but we also have regular interactions with them, and they send us their work that we also showcase in this way on the webpage. So now the majority of what we have done at CPR so far, and what I will present in this today, are our findings that are based on an attempt to answer the first question. That is, what are the background legal rules and assumptions that structure the property rights of the scheduled tribes to land and natural resources. But I will also say a little bit about the second question, that is how the federal political dynamics impact the legal rules governing the property rights of tribals. Kavita's presentation, which will follow mine, will focus more on the second question. Now, the ideas for this project grew out of the work I had done for my SJD dissertation. which, as well as my work as a public interest lawyer in India, working on issues of displacement and deprivation. My SJD dissertation essentially traces the historical evolution of the law of eminent domain, or expropriation as it is called in other parts of the world, from the colonial period, from the British colonial period until about 1970. And it examines how state institutions in India, first the British colonial state, and later within the independent Indian state, different institutions like the parliament, the executive, and the judiciary, manage the tensions between the individual's right to property and individual and the community's right to property, as well as the state's power to acquire property for the purposes, for various purposes. Now, the stated motivation of the British colonial state and that of the independent Indian state were quite different. The British colonial state wanted to redistribute or rearrange property relations as they encountered them, with a view to maximizing revenue for the British Crown, as well as to consolidate their political rule over India. The Indian state's motivation has been to redistribute property relations, essentially to bring about economic development based on a capital-intensive model of development, and also to secure social justice. However, as I will go on to describe, there exist significant legal, political, and institutional continuities between the colonial state and the post-independent Indian state, which means that as the consequence of that is that despite different motivations, the consequences of the policies of the British colonial state as well as the independent Indian state have often been quite similar, especially where they concern the rights of tribals and traditional communities. When I started my doctorate 5 years ago, I was motivated by this belief that the conflict over land and natural resources is really the most intractable conflict in Indian society today. And these questions are crucial not just to the path of India's economic development, but are also crucial to the stability of Indian democracy. And I'll say why. This is because contradictions within India's growth story, which pit very high economic growth rates in the last decade of 7 to 8%. Of course, growth has slowed down to about 5% now, but high growth rates against a vastly impoverished population, 37.2% of which lives below the poverty line. And of course, there's a debate also about where the poverty line should be. And there are estimates which would put it at over 40%. And we have 1.26 billion people. So that's a very large number. So these contradictions have provided impetus to armed resistance movement like the Naxalite movement, which according to the Indian government statistics engulfs 40% of India's geographical area today, 40%. Now, activists on the ground may disagree with the percentage, but they do not deny the significance of the problem. And along with that, this period of economic growth has also seen large-scale deforestation and environmental pollution, with alarming figures being released on a daily basis, both of the scale of deforestation that has happened, as well as the levels of pollution within India. These challenges become particularly acute, the challenges of development become particularly acute with respect to the scheduled tribes and other traditional communities like traditional fishermen, cattle grazers, and forest dwellers that risk displacement from industrial and infrastructure projects, which are seen as core to India's economic development model. Poverty and landlessness is rampant amongst the scheduled tribes. More than half of all scheduled tribes live below the poverty line, and 90% of them are landless as compared to the national average, which is about 40.2%. And what we find also is that even though the scheduled tribes constitute only 8% of the total population, they constitute 55% of displaced people. So 50 million people have been internally displaced since independence as a result of dams, mines, industrial development, and the construction of wildlife parks and natural sanctuaries. But the displacement has affected the tribal population disproportionately. Now, and these challenges have become particularly intensified in the last 2 decades, because post-1991 liberalization of the Indian economy has meant that there have been capital inflows, both domestically as well as internationally, as a result of which the need for land, minerals, and other natural resources for these projects has only increased, and that has in turn caused massive displacement, environmental degradation, and a deprivation of the livelihoods of traditional communities. And this has led to resistance and protests and struggles I mean, these are peaceful protests against the acquisition of land for the phosphor steel plant in the state of Odisha, and this by the Dongria Khol, which is one of the most primitive tribal communities, against bauxite mining in the Niyamgiri Hills by the Vedanta group. And when I say primitive tribal groups, it's a classification by the government. Because obviously we can debate about what is primitive and what is not. But so there are all these protests and there's massive resistance, and then there's armed violence by the Naxalite movement, which again, it's not clear whether they really represents the interests of the tribals or their own interests, but essentially there is this massive resistance that is simultaneously going on. So that's really the challenge. We have massive displacement, poverty, landlessness. But as we mentioned, there actually does exist a protective legal framework for securing the rights of tribals and traditional communities. And yet we have this really dismal situation that I've just described. So what is this protective legal framework, and why does it fail to achieve its goals? This framework is contained within the 5th and 6th schedules of the Indian Constitution. The 5th schedule provides for the administration of tribal majority areas in 9 states within peninsular India that have tribal minority populations. So what that means is that the majority of the population of the state is non-tribal, and then there are these areas that are carved out by the order of the president, which have tribal majority populations and are to be administered and governed separately from the other areas. The currently designated scheduled areas are in the states of Andhra Pradesh, Gujarat, Jharkhand, Chhattisgarh, Himachal Pradesh, Madhya Pradesh, Maharashtra, Orissa, and Rajasthan. And let me just show you on the map. These are, Gujarat and Andhra Pradesh are the states we are studying, but Maharashtra, Madhya Pradesh, Rajasthan, mostly within the peninsular part of the country. And within these areas, what we have is that they are administered by the governor of the state in consultation with tribes advisory councils that are elected by the people. Now, the governor has powers to regulate the application of laws that are framed for the entire state. He can regulate them so that they may apply or not apply to those areas, as well as form fresh regulations. And of course, they can also declare an area to be a scheduled area, and they can also, change what is a scheduled area or not. Now, India is often described as a union of states, just to give you a bit of context to understand what that means. So, India is a union of states. What that means is we are a federation, but with a unitary bias. In that the federal government has much, much more powers, both under the framework of the constitution and also much more economic resources than the rest of the states. What we also have is a parliamentary system of government. What that means is that the president and the governor really act on the advice of the council of ministers, which are in turn elected by the people in a parliamentary representative system. So the implication of this background framework for how these areas are actually administered is that there is considerable centralization of power. And what this also means is that there is no recognition of tribal sovereignty over the land and natural resources in the scheduled areas. There is only recognition that the tribals have a special status, that they need protection, but there's no recognition of their sovereignty. Sovereignty rests with the state. Now, for 50 years, this was the situation. But in 1996, the Indian Parliament passed the Panchayati Extension to Scheduled Areas Act, which has devolved some power to greater power to the tribal people in the scheduled areas. What must also be noted is that the tribal populations are not limited to the areas that are designated as scheduled areas. In fact, there are many states, so the ones that I mentioned, there are only 9 states that declared, and the way this happened was very sort of ad hoc. It was basically at the time the constitution was being drafted, the states had to send a list of areas that they wanted to be declared as scheduled areas, and over time they could change it, but pretty much that's how they did it. So there are many states, for instance, and this map will show you, unfortunately the lettering is not very clear, but juxtaposing this against the map that you saw before, all of these states have some tribal populations. Only the white, the states with, only Punjab and Haryana are seen as having no tribal populations. And yet not all of those states have scheduled areas listed in the 5th schedule. So obviously there are many areas where the tribal populations that are not covered within the protective framework of the 5th schedule. And often you find the case that, contiguous areas that are scheduled areas, and then there'll be areas contiguous that are not designated as scheduled areas, and it's really where the cutoff line falls that is in essence arbitrary. All the fifth scheduled states have in fact land transfer prohibition laws. What that means is that land within these areas cannot be transferred from the tribal population to non-tribal. So they do have, and all of these states have enacted those laws. There's a vast legal framework that over the last 60 years, various points of time, different kinds of laws have been enacted to actually secure this. What we also have is the sixth schedule, which provides for the administration of tribal areas in the northeastern part of the country, which are mostly tribal majority states. These are the states of Assam, Meghalaya, Mizoram, and Tripura. And as you mentioned, we wanted to actually study both Meghalaya and Mizoram, but we've had to restrict ourselves to Meghalaya. And just to see them on the map here, so these are the states in the northeastern part. So there's Meghalaya, Assam, Mizoram, and Tripura, very small states in the northeastern part of the country. And the reason we wanted to study Meghalaya and Mizoram was because both of them are tribal majority states. 85.9% of the population of Meghalaya and 94.5% of the population of Mizoram is actually tribal. And they're also demographically very similar in terms of land mass and population size. Kavita and Hugo have been working on Meghalaya, and I'll let them speak more about the work they are doing there. The only thing I'll note here is that Meghalaya is also different, not just from the other northeastern states, but from the rest of the country, because it has a matrilineal system of land ownership, which the other states don't have. Pallav and I have been working on the fifth scheduled states, and once again to remind you, Gujarat and Andhra Pradesh here. Yeah, so this is a map of Meghalaya. Meghalaya is also interesting because the whole state is pretty much recognized as a tribal state, so all the districts. The red dot shows the tribal districts. But turning now to Gujarat. Gujarat, as you saw from the earlier map, is a state in the western part of the country with one of the highest economic growth rates. It was ruled for the past decade by the BJP. It's still being ruled by the BJP or the Bharatiya Janata Party, which at the time we started the project in terms of the federal political dynamics was the main opposition party. And at the center we had the Congress. But of course we've had elections in May, as a result of which the party in government at both the state level and the central level is now the BJP. The chief minister of the state of Gujarat was Narendra Modi, who is now the Indian Prime Minister. And 17% of the population of Gujarat is actually tribal in nature. It is concentrated primarily along the eastern side of the state. So these areas are actually designated as tribal districts. Apart from the tribal population, Gujarat also has, as does the rest of the country, also has a number of traditional communities, like the traditional fisherfolk community, with whom I worked in 2009-2010, and I will speak a little bit about the work I did there at the end of this presentation. But these communities are also facing issues of displacement and deprivation. Now turning to the map of Andhra Pradesh. So Andhra Pradesh, as you will recall, is a state in the southeastern part of the country. And this is the state where in this project, apart from the overview work that we've done for all of the states, we've done significant archival work and actually ready to go into the field next month, which is why doing this workshop now and getting your feedback is really going to be important, the questions that we get from you as we go into the field in December. So Andhra Pradesh is ruled by the Congress government, and which was, as I mentioned, the party in government for the last 10 years and had a crushing defeat in the elections in May. This state has undergone significant political change recently, which we could not have foreseen at the time we started this project. In February this year, this state was actually split in two parts, between Telangana, which is the purple part, and the green part, which is now Simandra. Historically, the state of Telangana was a princely state, which was ruled by the Nizam of Hyderabad. Now, whereas Simandra was part of what was called the Madras Presidency under the British. Now, just to again give some context here, when India became independent, it had areas that were under direct British rule, but it also had 526 princely states, all of which were ruled by different princes. These states were, these states joined or were merged into the union, either voluntarily or were forced to join into the union if they didn't want to. The Hyderabad state was one state which did not want to join the union. It was actually coerced to join the union in 1948. So India becomes independent in 1947. Hyderabad is coerced to join into the Union in 1948. And in October 1953, they cut out the part of the Madras Presidency, which is now Simandra, and they put together the part which is Telangana, which became independent, and they merged it to form Hyderabad State in 1956. So this state came into being in 1956 and is now divorced again. So, and you know, it's very interesting right now politically as well, because right now both states have their legislative assemblies functioning in the same capital. They're trying to acquire land to form a new capital, and that's a big issue, land acquisition to create the capital. Now, as you can see, there are 4 tribal districts that fall within this part, which is Telangana, now Telangana state, Adilabad, Warangal, Mehboob and Khammam. And then we have 5 tribal districts that now fall in Simandra: West Godavari, East Godavari, Visakhapatnam, Vizianagaram and Srikakulam. The total tribal population in the state is only 6.59% of the actual population. So, and what we find here is that the population, the scheduled tribe population in the tribal areas, the designated tribal areas, is actually only 3/5 of the total tribal population. 2/5 of the tribes actually are living outside of the scheduled areas. There are 35 tribal groups, of which 8 are classified as primitive tribal groups. And the literacy rates amongst the tribes are much lower than the state average. So there's only 37%. And of course, the literacy rates will vary also between the tribes. In fact, recently 2 tribes have actually been denotified. So there's also movement within what is a tribe and what is not a tribe. Now, the broader narrative of poverty, landlessness, and displacement that I narrated at the beginning for the country as a whole can also be seen at the level of the state of Andhra Pradesh. So what we find is that non-tribals own approximately 50% of the land in tribal areas. So even though there are land transfer prohibition laws, non-tribals actually own 50% of the land in tribal areas. And there is also, in some districts, the alienation of land is as much as 70%. But what we have also found that this narrative of displacement for the state of Andhra Pradesh is not linear. So what we find is that there exists a lot of laws that were drafted and enacted at various points in time to stop landlessness, and there was rehabilitation as well at various points in time, but then there was displacement again. So what are the reasons for this displacement? And so at least for the state of Andhra Pradesh, what we've identified are 4 or 5 main reasons for this displacement. We'll probably as we do more work in the other states, we'll have to see whether those reasons play out in the same way or there are other reasons or not. But for the state of Andhra Pradesh, these are the major reasons. A large part of the scheduled areas are densely forested, where the scheduled tribes were pursuing a variety of subsistence occupations, including hunting, gathering, as well as shifting cultivation. In Andhra Pradesh, this form of shifting cultivation is called the Sivai Jamabandi tenure. And it's called by different names in different parts of the country. This reason is probably going to be similar across the different states. Now, before the British came to India, these heavily forested areas were mostly left untouched by the kingdoms. There was things that the kingdoms did, and I'll come to that. But for the most part, the very densely forested areas were kind of left alone. There was little mingling between the tribes and the more socially and economically developed population within the various kingdoms. However, as the British gradually extended their administration over the Indian territory, they extended control and asserted sovereignty also over these densely forested areas. By the enactment of various laws, including the Indian Forest Act of 1878, which was followed, of 1865, which was followed by the Act of 1878 and later by the Indian Forest Act of 1927, essentially what the British did was they vested themselves with the power of classifying any patch of land with trees on it as a forest, either a reserve forest or a protected forest, and there were these categories that they created. But essentially within a reserve forest, they made illegal in one stroke essentially all the people who were living in those forests and what they were doing there. Now, recently, as a result of massive public campaigns and civil society movements over a long period of time, the Indian government enacted the Scheduled Tribes and Other Traditional Forest Dwellers Act, or the Forest Rights Act of 2006. Now, this act has tried to redress this historic injustice by recognizing the rights of forest-dwelling communities to land and natural resources, denied to them over decades as a result of the colonial laws. Actually, Anand's work is exactly on the Forest Rights Act, so I'm hoping we'll hear from him more about the problems with this law. One of the problems that I do know is the fact that, again, we have these cut-off dates for when people can make claims and when they can't make claims to protections under the Act, and that is necessarily arbitrary as well. So that obviously works to disadvantage some groups over others. The second reason that we see is is essentially migration and interaction with non-tribals. Now, both during the various dynastic kingdoms that ruled what is present-day Andhra Pradesh, and more extensively during the colonial period, migration, both as a result of population increase, but also due to encouragement of settled agriculture, which was happening even under the kingdoms, but happened in a much more systematic way under the British, as opposed to the shifting cultivation of the tribals, resulted in the settlement of non-tribals in tribal areas. Now, during the late 1930s, the tribals, for instance, of Adilabad district, which is the district where there has been maximum alienation of land to non-tribals, were subjected to a dual onslaught. One was by the non-tribals who encroached on the agricultural lands, but also the forest officials who expanded the boundaries of the reserve forest at the expense of their traditional habitat. But again, this process was not linear, and I'll mention just one instance. So, following extensive work done by an Austrian anthropologist called Hemmendorf, who essentially was interned in India during the World War because he was an enemy alien. But luckily, the Nizam, instead of forcing him to stay in his bungalow, allowed him to go and study all the tribes. And he did extensive work, as a result of which, after the war, between 1945 and 1950, the Nizam actually started a policy of rehabilitation of the tribals, and there was rehabilitation that did take place. In fact, there were 12,000 tribal households that were rehabilitated, and 160,000 acres of land was redistributed. But what we find then is by the 1970s, most of these tribals were again displaced by many of the factors that I've talked about. Interaction with the outside world also brought the tribal people into contact with more sophisticated forms of property and commercial arrangements, especially the moneylender, who has been the bane of the peasant as well as the tribal peoples, in that they would take money and not be able to repay it and then lose their lands. There is also alienation of land due to intermarriage between tribal and non-tribal peoples, and there are many instances of people marrying or keeping tribal women as mistresses just to take over the land. And of course, there are inter-tribal land conflicts because some of the tribes are more, sophisticated economically and commercially than the others, and so there's a lot of these are not homogeneous groups. There's a lot of variation and between the tribes themselves, and that also leads to alienation of land. But of course, a big reason also for the alienation and displacement is land acquisition by the state for dams and irrigation projects. So because, as I mentioned, there's no recognition of tribal sovereignty over the land in these areas, the Indian state can and does continue to acquire land in the tribal areas for various projects. And just to give you an idea, in the last decade alone, 26 irrigation projects were notified within the state of Andhra Pradesh. And the largest of these is the Polavaram Dam project. This project is estimated to submerge 94,357 acres of land in the scheduled areas, 3,223 hectares of forest, and displace 276 villages containing 45,000 families. And then, of course, now, increasingly, there's a lot of displacement due to mining. Even with the creation of the 5th schedule and the various land transfer prohibition laws, the British state always retained to itself the power to the right to resources under the soil, so even within the scheduled areas, the state has always diverted land for mining, first by state industrial corporations and now increasingly with privatization and so on to private industrial groups. So between the period, just to give you an idea again, between the period 1980 to 2008, the total land diverted for mining was 18,178 hectares, which is 16% of all forest land within the state of Andhra Pradesh. Last year, however, and that's why it's important to see the different political actors. Last year, however, the Supreme Court gave a judgment which has rejected the notion that the Indian state does in fact have sovereignty over all natural resources within under the soil. So in this case, for the Trisamaya case, the court held that the Indian state only succeeded to the rights and obligations of the British colonial state. And it goes on to show how the ownership of mineral resources under British times was different in different areas, and you cannot automatically assume that the British government actually had sovereignty over all resources under the soil. And so you kind of have to see it area by area, And so in that sense, it creates scope for claiming that actually within the scheduled areas, the sovereignty over the natural resources lies with the tribal people. So from all that I've said so far, it is clear that even though there are laws and protective frameworks put in place to protect the rights of the scheduled tribes since independence, what we find is that there's the continuation of a variety of colonial laws based on the assertion of sovereignty of the British colonial state and the Indian state to all land and natural resources within Indian territory. And the negation of tribal sovereignty even within the scheduled areas is responsible for large-scale displacement and deprivation of the scheduled tribes. Of course, there's also considerable failures in implementation of these laws, which a lot of people have written about. And of course, I think Kavita's presentation is also going to show more the failures in implementation of these laws. But our research, I think, has brought out in a very significant way that the background legal rules and assumptions are so skewed against the interests of tribals, and the continuities between the British colonial state and the Indian state make it such that the protective frameworks really don't have much of a chance in protecting the interests of the tribals. Finally, I want to say a little bit about the other communities that, even though not tribal in nature, are also vulnerable groups pursuing traditional occupations whose livelihoods are threatened by the larger process of development and displacement, because there is no recognition of their customary rights and their livelihoods. So here I'd like to say something about the traditional fisherfolk community, which is mostly concentrated in the Kutch region of Gujarat on the western coast. And this is the group that I worked with in 2009 and 2010. I worked with an organization called the Machimar Adhikar Sangharsh Sangathan, which was basically working with traditional fisherfolk, or Pagadia fishermen as they are called, in essentially trying to, the organization itself works with the fishermen to organize themselves and help them sort of market their fish and so on. But they were also supporting them in litigation against displacement by various industrial projects, as well as the Mundra port and special economic zone that were being constructed in that area. So these fishermen have been fishing in a customary fashion, where they sort of wade into the water with their nets. So they don't have boats, and they fish in these areas which are covered by mangrove forests. So they wade into the water with their nets, and there's only a 14% literacy rate, and the only skill they have is fishing, and they've been doing this for over 100 years, and they have these fishing permits that are given by the state. So they live on these makeshift huts on what are called bandars around the coast. So the bandars are these pieces of land which are all around them is water, and in fact during the monsoon season this land will also be submerged. The monsoon season is for 4 months of the year, between say July and September, and for the rest of the year, these patches of land are above the sea. So they live in villages inland, but they go and work on these they live in these huts on the bandars for 8 months of the year. And the government obviously recognizes that they are there because it provides them various facilities like mobile toilets and stuff like that. So there's a recognition of the fact that they are there and they're working in this way. And so this area should be covered with mangrove forests, but they've actually been cut down. And the mangrove forests provide the breeding ground for fish. The fishermen wade into the water with their nets and catch the fish. And so there's this delicate balance between man and the ecosystem, because the mangrove forests support the fish, the fishermen catch the fish, and they use it for subsistence as well as for the market. But what we find now is that with the construction of the construction of various projects, like this was the OPG power plant. This project had just started operations when I got there in Gujarat, and essentially this project planned to discharge hot untreated water into the sea, which would have disrupted the salinity level. It would have increased the salinity level, and as a result of which killed all the fish. So the fishermen were protesting against the acquisition of land for this project. And so while working on this case, I realized that there was no recognition of the customary rights of the fishermen over the bandars, even though they have been living on this land for generations. And so the way we structured the arguments in this case was really to challenge this as an environmental law violation rather than the rights of the people who were living there, because that was the only way we could make a legal argument. The other case that I was working on, and was ongoing when I got there, is the Mundra port in special economic zone. This is a massive port which is being constructed in India. It's supposed to be the largest port in India by it's called the people who are behind this project, the Adani group, call it the Rotterdam of India. And this case was extremely challenging. It's still going on because this entire area should have been mangrove forest. And when we got there to fight against the fact that this land had been illegally cut down, we realized that the mangrove forests are already gone. But recently, last year, actually, the Ministry of Environment and Forests imposed a 1 billion rupees fine on this industrial group for cutting down the mangrove forest. And this is the largest environmental fine that has ever been imposed in India. But of course, since then, there's been a change in the government, and we haven't really seen an implementation of the fine. But also the fact that, the fine is one thing, and yet the forests are gone, and the people who are, dependent on using these resources for their livelihoods are also still displaced. So I think that the larger question of the state's power to give away these common property resources of land and the seas for industrial development and negate the customary rights of people dependent on these resources for their livelihoods remains to be answered. And I think that this challenge is particularly, is obviously very acute in the case of the scheduled tribes. But in the case of other tribal communities like this community, the question that we have is they don't even have those protective frameworks. So it's an even perhaps bigger challenge for them. And so I'll just end here.